I will quickly just add that I have been trying to get Monica Smit to send me the paperwork that she has, her filings and whatnot for the case that she has. And I've been trying to do that for a few weeks, but with no luck so far. I have written a few comments under some of her videos, sent her some information like a crash course in cross examination and stuff like that. But, you know, that hasn't so far proved effective. I haven't received an email back. I don't know if Monica Smit checks her own emails or whatnot, or if there is some kind of gatekeeper blocking that. So this video is the most effective way to get that information to her. G'day everyone, and welcome to RJ Martin's This Is Not Legal Advice, episode 184, or TINLA for short. So this video pertains to current COVID restrictions / vaccination cases, in particular that of Monica Smit, ref Reignite Democracy in Victoria, hence the green background. Green is the state colour of Victoria for those of you that don't know, and blue for New South Wales, maroon for Queensland, etc. But anyway, this can also be used in part in Dr. Valerie Pierce's case. She's a doctor who got into some trouble giving vaccine exemption certificates, which of course, people shouldn't be forced to take any medications. And it also goes against normal medical law. You have to have fully informed consent, and that includes being told alternatives, the pros and cons, or risks versus rewards for, taking a medical procedure or not taking it, which invariably doesn't happen. And, medicine shouldn't be forced on anyone. Just ask some people in World War II. Anyway, for those of you that don't know, I'm RJ Martin. I do hold a Juris Doctorate Law degree, which is a particular type of law degree that you can get after you have a degree in some other field, so post-grad level. Anyway, I hope that gives some kind of credibility to what I have to say, because what I have to say is credible, plus also I do have training in the area as well as experience with COVID restriction court cases. So I did have what I believe is Australia's first COVID restriction court case. That was in 2020 in, I think it was the 29th of May. Where a certain police prosecutor who did perjury in the case to give the court purported jurisdiction, that was Sergeant Mai Arundale of Surfers Paradise Police Station. She's also a prosecutor, and prosecutors have special rules that they are supposed to be fair and even and honest, of course, with the courts. But sadly, that doesn't happen. Apparently very frequently. I would assume, especially doing a law degree and you have to do ethics and whatnot, and they basically claim that if any lawyer does anything wrong or prosecutor, they get banned and shunned by the industry and all their colleagues and blah blah blah. But obviously that doesn't happen, and there's more evidence of that than just that particular court case. Anyway, she committed what I allege is perjury by falsely claiming to the court in a sworn statement, as well as verbally, that we had the legally required mediation session in order for the court even to have jurisdiction. Basically, she, representing the police, was trying to prevent me from having COVID restriction protests, and also to grow a political party that I started, which was Reset Parliament Australia. And the idea of that party was that basically candidates and elected folk should represent the people and not a party. So instead of picking people and then forcing them to follow whatever the head honchos in a party decide in terms of policy, that the idea was to pick decent people to begin with that would do the right thing by the people and do it that way. Anyway, so along with that, basically, the police, via my Arundel, Sergeant Arundel, took me to Southport Magistrates Court to try and prevent me illegally from protesting and doing COVID rallies, that kind of thing, which I'd been doing since the 6th of April 2020. I was Australia's first COVID restriction protester, and then the next day I went out to a public park too, and police drove by and didn't do anything. But, it would have been interesting to see what happened. And I assume that the police were watching my Facebook Live and that they had watched the protest the day before, which was basically done in my backyard at the time. And during those protests, it turned out that only Germany had public protests before that, which I don't know if I knew at the time. I don't remember. I probably discussed it in one of those videos if I did hear of it. But on the 4th of April 2020, in some town in Germany, they had a public protest as well. So they beat me by a day and a half. Anyway, during that protest, I also pointed out certain interesting features of the COVID restriction laws and basically loopholes, if you want to call them that. And that included that people could protest whilst they were exercising, people could protest whilst they were shopping for essential goods and services, etc. People could write the messages of protest on shirts or whatever when they're just walking around, or they could be more vocal about it and then have those excuses as shields against prosecution. And when the police go there, say, oh, I'm exercising, you're allowed to exercise, kind of thing. I think it was about a week later or 2 weeks later, protests in America started in Michigan. And a week after that, I think it was, there were the protests start in Sydney with the Exercising My Rights group. And that was using, for the Sydney protests, my exact argument or process, method, whatever you want to call it, of exercising whilst protesting. Anyway, as a part of my own COVID court case stuff, I basically then had two conflicting lots of free legal advice. I did have a GoFundMe that kept being shut down by members of the Australian Vaccination Risk Network, by them falsely claiming that I was engaging in fraudulent fundraising, which was not the case. And it's very peculiar and ironic considering the AVN was banned from fundraising many years ago, and you can look up reports and Hansard, or the government newspaper from the New South Wales Parliament, where essentially they had their charitable status stripped and they were banned from fundraising for financial impeculiarities or irregularities or whatever way you want to call it. And this is just a summary, of course, but they've since raised millions and millions of dollars after that, as well as they took over my protesting movement and prevented me from speaking at my own protests, and were claiming that their speakers were a part of my authorised protests in Queensland to prevent them from getting prosecution, or prosecuted, I should say. Anyway, with listening to the two groups of lawyers, on one side there was a solicitor and a barrister. I know the solicitor, and the other side was who I listened to, that basically said, yeah, sure, just appeal. It turns out in Queensland you can't appeal no matter how egregious a decision is, anything to do with protesting under the Peaceful Assembly Act 1992. which is ridiculous in and of itself. The magistrate made ultra vires or above powers orders against me, which he had no power to do. He also made some other ridiculous points, which maybe I'll get into in another video, so this isn't so long. But anyway, so I did try and do the appeal route, which ultimately ended up in the Supreme Court's Court of Appeal, and they confirmed, hey, look, you can't do anything to do with appealing this. You may be able to, put in a claim and statement of claim as a separate process to the trial division of the Supreme Court, but unfortunately you can't do it as part of an appeal, and it is what it is. As a part of those proceedings, however, I did do a Section 78B notification to every state and territory Attorney General or their officers, and that included my legal submissions, and it includes this very important point. Some other interesting things as an aside before I get to the meat and potatoes of the matter is that Clive Palmer apparently funded 3 class actions in Queensland that had 2 successes and 1 failure. One was for members of the Queensland Police Service, and one was for the Queensland Ambulance Service. Both of those won, with Justice Glenn Martin of the Queensland Supreme Court stating that they were unlawful directions, and that includes using some of my arguments that I used in my own cases and put out in various places. I did also try to make my own submissions as a friend of the court when I found out that that was going to trial, but I don't know if that was accepted or not in the court. Technically you should do it in a certain format, but I sent the information to the law firms representing the class action members, as well as to the court itself, with the court asking for leave to be a friend of the court, i.e. to provide information to them that would be useful and relevant to the case. And then I think the other one that failed was for Queensland teachers, and I haven't gotten into all of the details or read the cases to see why they failed in that particular class action. But with the 2 successful ones, they were on the grounds of failure to comply with the Human Rights Act in Queensland 2019, which is one of my submissions that I had for why the COVID restrictions were invalid and illegal and unlawful and could not be legally enforced. So there are also some other arguments, such as constitutional arguments revolving around freedom of movement or intercourse, and some other particular matters, discrimination among the states or residents of other states, i.e. with these border crossings, and that quarantine was handed over to Group A, not Group B, so therefore Group B couldn't make any more laws to do with that, etc. Again, I don't want this to be a 5-hour video, and I'd have to read my own work to do it as a proper job. Anyway, one major part which can help Monica Smit in particular is, and also everyone else who got fined or imprisoned for COVID restrictions in Victoria as well as in Queensland. So in Queensland and Victoria, the COVID restrictions came from the Chief Health Officer and Chief Medical Officer. So it's a CHO in Victoria and CMO in Queensland. The Queensland CMO ended up becoming the Governor of Queensland, Dr. Jeanette Young, and she and Crown Law / the state of Queensland and the QPS were basically the parties in my own COVID restriction cases when they were on appeal, which, as I said, it turns out you can't appeal. But then with the money that kept being cut off, with the GoFundMe, etc., and people getting messages, when they go to donate, that the campaign's been stopped for whatever reason, claims of fraud, blah, 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 then obviously that turned people off. I think there was about $3,800 raised on there, and then GoFundMe took their fees, and then it ended up costing me something like $160,000. So, that was not so helpful. And you also had many lawyers that were qualified as lawyers, some of which have been disbarred since, do what amounted to prima facie fraudulent fundraising for cases. Again, I can get into the details of that later in another video if people are particularly interested. Otherwise, it is what it is. Anyway, so with Queensland and Victoria both having the COVID restrictions made by a non-elected Member of Parliament, so someone who's not an elected Member of Parliament because they weren't elected at all, then they have certain similarities. So in Queensland, as an example, we have the Statutory Instruments Act 1992, I think it is. I can't really see with this bright light in my eyeballs. But in particular, there were sections 47 and 49 that were particularly important. One relates to exempted subordinate legislation, which included COVID directions from the Chief Medical Officer. They must be notified or gazetted, which is you publish the information in the Government Gazette, and that's how it is notified. And then also tabled to Parliament. There's also parts about there must be Human Rights Act considerations, etc. That's also with the Human Rights Act 2019, which, as I said, was successful in arguing why the COVID restrictions on teachers, well, not on teachers, on ambulance and police in Queensland were unlawful and therefore illegal and therefore, a violation of rights and many other things. In Victoria, however, you have the Subordinate Legislation Act 1994, and they use slightly different language, but obviously they have very similar features. Some particularly interesting things are that of the need to gazette the legislative instrument, they call it in Victoria. So basically a law is not a law and is not enforceable until such time. Sorry about the video cutting out. So I was saying about notification. So a law is not a law, including regulations, until certain things have come about and they're conditioned precedent, so they must occur before the law or whatever is enforceable. So with an act, as an example, or a statute, it must pass both the upper and lower house of Parliament and receive royal assent from the governor if it's a state, or the governor general if it's the Commonwealth jurisdiction, or technically the now king could personally sign those into law, but they must be notified. They must be published in the relevant government gazette. So you've got the Queensland Gazette, you've got the Commonwealth Gazette, etc. Until that has occurred, then the legislative instrument or regulation or statute, etc., is of no effect and can't be applied, which is a big problem for the Queensland government and the Victorian government. As an example, in New South Wales, the COVID restrictions were actually from the Minister Hazzard, So that is a different story, although obviously other things can affect the validity in New South Wales. But that being said, I do suggest that the Subordinate Legislation Act 1994, Victoria, be looked at by Monica Smit and also brought up in the court case, including in cross-examination of the relevant police or government officials that will be witnesses at that trial. And, I would be making sure that they can prove that the COVID restrictions before Monica Smith's arrest, and you can even do it since, but that they were published in the Government Gazette. And I think you'll find that they haven't been, but I don't have hours and hours to go through Victorian Government Gazettes. I did previously years ago, but I would have to redo a thorough look. But obviously, when you have the police on the stand, you can say, when was it published in a Government Gazette? Oh, I don't know. Okay, well, that's very important, because is it not correct that if it hasn't been published, that it has no force in law? And, you really ask more like 10 different questions, but there's no point me putting exact questions here anyway, because obviously they can watch this video and, even though it's not really going to help them, because if it hasn't been published, it hasn't been published. But you have certain sections of this act which are very important. So another one is there is a requirement for a human rights certificate. So in Victoria, they, instead of having the Human Rights Act 2019 that we have in Queensland, they have the Human Rights Charter, and that must be considered. They do have an exemption, which there may well be an exemption in this case, for that particular feature, and that includes public emergency, but that also requires a public emergency to be announced, which I'm sure there probably was without checking. But then there must be a human rights exemption certificate, which I don't know if that's in place. So that's one particular thing. So that again is similar to, or an analogy of what happened in Queensland with the two class actions. And the next very important section is Part 3A, Tabling and Publication of Legislative Instruments. So you have 16A, legislative instruments to be published in the Government Gazette, and that's found at page 37. You have 16B, legislative instruments and related documents to be laid before Parliament. So again, that's to do with tabling with Parliament. And then you've got 16C, legislative instrument and accompanying documents to be sent to scrutiny or scrutiny committee. 16D, compliance with this part and requirements of authorising act publication in the Government Gazette. 16E, compliance with this part and requirements of authorising act tabling in Parliament. And 16F, instrument maker to ensure consolidated version of legislative instrument is available. So they are very important because, as I said, and just to summarise, if the COVID restrictions were not, well, let's say the human rights stuff first. If there was not a human rights certificate or a human rights exemption certificate, then that's particularly one issue showing that it's invalid COVID restrictions. But then the other important one is if it hasn't been gazetted, which is notification to the public, then it can't be in force and it has no force in law. And therefore, when people like Monica Smit or Real Rushkin or whoever were arrested, and other protesters, this darn video keeps cutting out. I was saying that when people like Monica Smit and Real Rushkin and Avi Yemini and whoever else were arrested under the grounds or the pretext that, oh, look, there's these COVID restrictions and you can't be in a group, you can't be out, you're not out doing essential things, blah, blah, blah. And, even Joe Public, as in the normal rest of us, that were fined, they were invalid fines and they should all be refunded. And that should occur in Queensland and Victoria on the same grounds. And if it wasn't the law and it couldn't be enforced because the law or purported law was not in force, then all of those people basically had their rights trampled on illegally, even under the government's own rules and regulations, because the idea is that the government cannot interfere with your rights unless they have special permission to do so. And they didn't have the special permission to do so if it wasn't notified in the Gazette, tabled in Parliament, and in compliance with the Human Rights Act in Queensland or the Human Rights Charter in Victoria, or with the relevant subordinate legislation acts. So the Legislative Instruments Act in Queensland 1992, and in Victoria the Subordinate Legislation Act 1994. The reason why I was fundraising was for things like filing costs, employing a barrister who is an expert in procedural law. Obviously, if that went through and the fundraising efforts weren't destroyed, then things would have been done with the same substantive law, which is something that I'm good at, but not procedural law, as I said at the time in the fundraiser videos. But it'd be done as a claim and statement of claim, as opposed to trying to do it on an appeal when you can't do that as an appeal. Okay, good luck everyone. Over and out. Please like, share, subscribe, send this video to everyone, including to Monica and Dr. Pierce, and get the word out there. The more people that know about it, the more effective it will be, and the less of a surprise it will be for the government to find this information and all of a sudden actually act on it, and for the government to act lawfully and not falsely imprison people, not extort them for money that they had no right to ask for in the form of fines and forfeitures without the required legislation going through, or subordinate legislation, and without it being enforced. Anyway, have a lovely day, and as I said, good luck.